Hi, this is your friend, not your friend. I'm on your side, Dr. Cora Stack here. Just to clarify, I have a Doctor of Philosophy in pure mathematics. So while I'm very interested in psychology and psychiatry, brain health and neuroscience, I'm fascinated with the brain, and how people think and all of that, and the thinking processes and things like that. I'm actually, my original expertise is in pure mathematics and probability theory. I suppose I have a very good knowledge of that. But pure mathematics is it's the queen of all sciences, that's for sure. So what really happened in Ireland's 2025 presidential nominations? Now, this is following a lot of interest in the paper, a joint paper by myself and Miss Maureen Kenny, and she's an excellent political scientist, and this is, I think, one of her first major papers, but it's making with myself, and we have combined two ways of looking at it. She's looking at the administrative side and what happened at the county council level, and I'm looking at it from the constitutional point of view, but they're all really rooted. You can root them all in constitutional questions. So this is why we've brought it to the we're bringing it to the courts, because we believe there are constitutional issues here that need to be addressed based on facts, truth, justice. Look, we're not in the business of criticising people. Perhaps we're seeing that. We're in the business of, trying to move forward positively and learning lessons and changing things for the better, improving things for Ireland. And we think that we have the possibility here if we were listened to carefully, but we have to focus on the facts. So, facts and truth is what we're about, not winning or shaming anyone or putting egg on anybody's face. That's not what we're about. We're not interested in, humiliating people or anything, even if it was done to us. We're not vindictive. I'm not a vindictive type of person, so I don't think that wins anything. No. So in 2025, Ireland's presidential election followed a nomination process unlike any since the Constitution was adopted in 1937. For the first time, it's kind of hard to believe, for the first time in the history of the state, no independent or non-party candidate succeeded in securing enough local authority nominations to appear on the ballot. I think this is very important for people to understand, the facts, because people are basically being saying, Corey, you were wrong to the court, like we've been following you on YouTube, and so we were delighted that the public are beginning to see it, but we kind of need the courts to help us out here, and well, the video explained, but there are people coming up to me in the street and saying, Cora, you were wrong, I'm following, the facts speak for themselves, you were wrong to the court, and so was Mr. Niall Byrne, etc. And they'd also say it about Mr. Enoch Burke. I know that's where he was wrong as well. So I'm just saying what people are saying. Maybe I'm meeting, I'm not meeting. Maybe there are people that are, it's a very polarizing situation. But I think to heal, we all need to. To heal, look at what will heal these problems rather than winning or losing, or losing face. No, it's healing. We have to focus on what are the policy options, or that will heal, the wounds, or I'm talking about moral injury. Maybe we've all got moral injuries and we all need to heal. And if we looked at it as healing rather than protesting or all of that, we might look at the healing and focus on what is the solution for healing here. And I think that's our light, as Niall Byrne. That's a better way of looking at it. And does that feel better than winning or losing face? Look at the long run. What is going to heal all of this conflict? That's how I change my position now very much on this. So because of looking at the other ways that exist, and so I'm for healing rather than complaining. So this video explains what happened, why it matters constitutionally, and why legal scholars argue this was unprecedented. Now, I'm just a student, not a scholar. I'm approaching a scholar, I suppose. I never like to overestimate myself. Article 12 of the Irish Constitution. This is really fantastic, Article 12. So everybody should know this now after this lecture. Everybody should know this off by heart. And then we're on a winning streak. So we're not a winning, but on a healing road. Back to hÉireann, we all understand Article 12. Article 12 of the Irish Constitution sets out 2 routes for a person to become a presidential candidate: nomination by at least 20 members of the Oireachtas, or nomination by at least 4 local authority councils. The local authority route is particularly important, absolutely, and it's guaranteed in the Constitution under Article 12 there too. It exists to ensure that independent non-party candidates can access the ballot without reliance on party structure. Sure, it's a fundamental part of the Constitution which is trying to preserve the democracy on which the Constitution and which the country was founded. The Constitution was founded. So it's absolutely critical to democracy to preserve those 2 routes. And certainly the one that's most likely to be attacked is the second one. So that's the most vulnerable, in my opinion, obviously clearly from the evidence here. Since 1937, this route has always functioned in practice until 2025. In early September 2025, national broadcaster RTE reported that all the leaders of Fine Gael, Simon Harris, the current Taoiseach, issued a nationwide instruction to all Fine Gael councillors. The instruction was then described as the block, BLOK or BLOCK, block. Do not nominate any independent presidential candidate. This was not a parliamentary whip. It was a directive. Under the Constitution, it's a better word to, under Article 12, as I understand, or Article 28, it's better to call it an action, the same thing. A directive or action aimed at local authority members acting in a constitutional nomination process, not a legislative role. This is very important, that distinction. You know, I'm learning myself all the time. You know, the more you read, the more you learn. You know, so it's like lecturing. You know, you learn as you lecture. You learn as much as you teach. Multiple councillors publicly described the instruction as unfair, dangerous, and a threat to local government. So there was concern from councillors. In fairness, they, you know, not to say they were concerned, but I mean, they were subject to extraordinary pressure, I think. So the immediate outcome, the consequences were immediate and measurable. No independent candidate secured the required 20 Oireachtas nominations. Only 3 councils at most nominated independent candidates, and that's in a fantastic map in the paper. It's all red, you know, red kind of. Would you put it red or blue? Which one would you put it? But anyway, it's a fantastic map. You can see it very clearly from the map, you know. So the Constitution requires 4. As a result, the local authority route effectively collapsed nationwide. I think this is very clear now. This is the facts. This has never happened before. A constitutional mechanism designed to widen democratic access. That's just for me, you, anybody else. You know, it's for all the people there who were absolutely... I went around and I saw the devastation on the faces of all the other independent candidates. They were devastated, didn't know what was going on. They just, their esteem, you know, they were morally injured. That's the one word for it. They were all morally injured, to use my latest. They were very harmed, you know, because, you know, it was deliberate. Well, I mean, the consequence of it was moral injury, moral injury. And I suffered terrible moral injury. Well, I've had quite a number of moral injuries, as I now understand the concept. A constitutional mechanism designed to widen democratic access was rendered non-functional, not by law, referendum, or parliamentary debate, but by party action and instruction. Why the whip argument matters. Political parties commonly use the whip system to manage voting discipline. We know that inside the Oireachtas, that's regular. But constitutionally, historically, the whip only applies to TDs and senators. Well, the whip is a person, you know, it's a person. It's a designated person. It exists only in parliamentary legislative business. It has never been applied to local authorities, and in particular, it has never applied to presidential nominations. Local authority councillors are not party employees. They are statutory office holders with legal duties that override party loyalty. Now, this is very difficult for the councillors. You know, this is why obviously there was concern among councillors. Under the Local Government Acts and the standard in, it's called the SIPO, Standard in Public Office Code of Conduct, councillors are obliged or must act impartially, avoid predetermination, make decisions on merit, resist improper influence. I mean, that was made impossible because, I mean, I heard stories that if they didn't do what they were told, they face sanctions, allegedly. So this was fear, this was fear in an awful lot of them. So, it put them in an impossible, it compromised them hugely, I think. So I have great sympathy for being in that position. Act in good faith and in the public interest. A directive requiring councillors. I mean, it would be like, people in the past in the Dáil who've come out and, their careers were ruined for speaking the truth. We won't, there's a particular doctor there that felt that his career was ruined for speaking the truth. Against the Tide. That's a brilliant book worth reading. So, a directive requiring councillors to reject all applications regardless of merit constitutes predetermination, improper influence, a breach of statutory duty. Now that's very hard that's really difficult. But you see, all of this can be framed in terms of constitutional concerns or constitutional issues. So when statutory safeguards fail, also, this is the point, constitutional safeguards are placed at risk. So this is why this can all be looked in or circled around with constitutional questions. So this is where the constitutional side of it comes into it. So the paper identifies impacts across several constitutional provisions. Article 1, sovereignty of the people. Now, a lot of us, I didn't even know the Constitution until I started looking at it. So it's useful. I've converted it into lay language, and a lot of the law people around the world are using it or reading it because they understand the layman's. But of course, I'm saying it's not legal advice, but it might help you understand the Irish Constitution, and maybe they might decide to do it with their own constitution, because I think everyone should have a layman's guide to their own constitution. So this is I'm surprised at how much interest the legal scholars or the legal students, especially the graduate legal people, are in this paper. So it's just something I had to do for myself, so I shared it on Academia.edu. So Article 1 is sovereignty of the people. Article 6, lawful exercise of power. That's a very narrow. They can go into that in greater detail. Article 12, presidential nomination. Article 28, limits on executive authority. That's very important. So I saw 12 and 28 are very important here. Article 29, good faith in government. And Article 30, oversight of constitutional processes. You could put in a couple more as well. So you can kind of surround all of this with these constitutional concerns. The core argument is straightforward. A political party directive has no constitutional authority to alter or neutralise the constitutional process. So legal challenges are brought to the High Court, arguing that councillors' statutory duties override party instructions. Now, so that's a very serious question. Citizens cannot be subjected to party discipline in constitutional processes. Another very serious constitutional question. Only legalisation or ministerial regulation can alter local authority procedures. So that's an insight from Miss Maura Kenny. That's the third one. The High Court rejected the challenges on justicability grounds. However, the judgments did not directly engage with SIPO obligations, ethics law, with constitutional law as well, predetermination, statutory independence of councillors, and the unprecedented national scale of the rest, of course, the constitutional questions concerns. These issues remain constitutionally unresolved. The election proceeded, but the democratic effects were visible. Over 213,000 spoiled ballots, an unprecedented number. Widespread public disengagement. I know piles of people said, I'm not voting because what's been done to you. What's been done to you? The church, they said, I'm not voting. They weren't going to, but they said they weren't going to vote because they were so concerned about how I was treated in the courts. And I'm sure that, these were very brave people that did this on my behalf, But they didn't spoil the votes, but they refused to engage in the process because they felt I had been, and Mr. Byrne had been poorly treated. We're not treated. We were treated with disrespect because we were the unrepresented, which John Grisham is now saying is the cause of a huge amount of innocent people on death row being executed. So I'm a great fan of John Grisham because of his work for justice, and he does a huge amount to help innocent people on death. Oh, it's incredible because it must be very difficult for them, but He's a brilliant writer, by the way. He knows his stuff inside out. National and international media concern. Cross-party criticism for academics, councillors and commentators. The paper does not argue parties and politics. We're independent. We're not. It's not about winning here. It's about healing. So I'm trying to make the point that there's a lot of big decisions to be made over the next while, and it's about healing. Everyone's saying about the darkness in the country. The darkness is full of evil and it's full of corruption. No, it's about trying to heal. Finding ways to heal the wounds that we're all carrying in some kind of. And it's just trying to put out that message of healing and what would that look like in future justice systems. I'm quite ambitious because my papers on arbitration first before court are getting a huge amount of traction worldwide, and a lot of other papers are, but that's at the core, I think, of a lot of the interest that the justice system needs to tilt towards arbitration. That's just a shift. It's not a revolution that we have arbitration first, mandatory arbitration for most conflicts. Justice Toomey there was very sensible yesterday. He was talking about a bullying case where the legal fees were, I think he's come out a few times. That judge is very sensible. He's seeing these impossible. It's not a game for money for solicitors, particularly when people can't afford it. So an arbitration first system there for that might have been a far better system, for all in those circumstances first. And if that didn't succeed, then courts are obviously the courts of last resort. So it asks the constitutional question. If Judge Toomey was an arbitrator, the legal, he'd probably made the same, decision, but the legal costs would be far less than what is currently being paid. When he'd made a brilliant arbitrator, because he's always talking about this, and he's aware that illegal costs are excessive. So inevitably that's going to stay unless we change to an arbitration, an affordable system. So Justice Toomey is really just saying what I'm seeing. But I'm seeing it in a different way. So, I won't say he's saying what I'm saying, but he's echoing my concerns. I wouldn't say so I don't want to put words into his mouth, but he's come out a few times about this, as far as I know. So this fellow is, a very reasonable judge. So there are very reasoned judges in the courts, so we can't say they're all, one way or the other. So Irish Constitution, and we're very much reliant on those reasoned judges, like Judge Higgins was extremely reasonable. So there are reasonable people here, and we really want them to, to help us, if they can, so I don't know whether they can or not, but these are reasonable people that have, great talent and great sense of justice. So they're not in it for the power, they're in it for the justice. And I really like those judges that are for justice rather than power, and fairness and balance. Those people really are impressive. And they're there, but you don't always, they're not always assigned those kind of justice. And maybe the ones who are not assigned they have their own wounds and their own trauma, and this comes out in these kind of maybe unfair, justices. So we have to kind of healing, mention that over again. So the people are the masters. Yes, Ireland's constitution rests on a single principle. This is very important. The people are the masters. In 2025, that's very important. None of us consider us as masters, but I think it's very important that we mention that the people in general are the masters of the Constitution. The 2025 nomination process marked the first time a constitutional pathway was neutralised by party instruction rather than law. Whether this becomes a precedent or a constitutional line never crossed again is now a matter of public reflection, legal scrutiny, and democratic accountability. So that's really where we're at, really, and this is based on the final version of the paper that's gaining a lot of interest on platforms like Academia.edu, in particular on ResearchGate, called Constitutional, because I have so many papers. There's a lot of interest in a lot of my work, so I'm huge interest, particularly in the access to justice and the arbitration mandatory first, but a lot of the papers really are because of the lack of that. Because of the lack of that, a lot of the papers are really kind of follow. A lot of the injustices are from the lack of that, the lack of affordability of access to justice, which interestingly, John Grisham has been raising for many years to do with. to do with fairness in death penalty, in the death penalty situations. And I have to greatly admire him, because I think that was one of the hardest things to do, to support and finance privately, cases where he believes there is an injustice. I wish he could support us, but I'm not asking him. So, constitutional constraints on political party dominance and the integrity of local democratic governance. So that's getting a lot of attention, because I get the feedback is the Kenny and Sack 2025, and I have to give Maureen great credit for approaching me. She knew I needed help, and she knew she had the insight, and she was watching Roscommon. And she knows that what happened there is that, but I think that Roscommon is a mirror, in the language of the brilliant Jordan Peterson, on what happened in a lot of the constituencies, a lot of the. So I think it's brilliant that she has recorded that absolutely truthfully and accurately. So it's to me now it's all about healing and trying to convince the parish that we're not people that are out to get anyone or to be vindictive. We're all wounded in our own way, and trauma. That's why you see the trauma informed, because it recognises that everyone has their wounds, and they project them in different ways. Some people can internalize them, some people can't. It's just your genetic disposition sometimes. Like John Hume would always say, we're the accident of our birth. Really, he had that great line that he used over and over again. And it's hard when you feel badly treated, to look at it from that point of view. But I think unless we take the vision of John Hume for healing, in the Northern Ireland, draw a line and move forward. I really think he's fantastic. What he did was fantastic, and he had the one-liner. But my one-liner is arbitration first. But I've done several papers which I think follow from the lack of affordable justice. So arbitration first is mandatory arbitration first, and there are a lot of judges and a lot of lawyers who could be excellent arbitrators and well paid, with a pension and stuff like that, but they would have to be independent of the state, some way independent of the state, so that they couldn't, a kind of a separation of powers. I don't know how you'd put that in an arbitration act, but we couldn't have them siding with the establishment because they were paid by the independence of the arbitrators is absolutely critical. No conflict of interest or anything like that. So this is my bet on this, and I hope this helps to inform the public, who are very concerned at what's happening here, and that the truth seems to be up to now suppressed in Ireland by people perhaps who are, I don't know why the truth is being suppressed, but perhaps afraid of the government, or afraid to rock the boat, or perhaps, I don't know. I have no answers here. We're just asking questions, and we're looking for healing, and we're looking forward, and we're looking for the truth to be validated.